All right, if you're a law student in India, you know there are some cases you just have to know. They're not just precedent, they're basically the pillars of our entire criminal law system. In this explainer, we're going to break down the landmark judgments that have shaped everything. Let's get right into it.
So, let's kick things off with a really basic question, but one that gets to the absolute heart of criminal law. I mean, it seems simple, right? But the legal answer is what separates, say, an unfortunate accident from an actual punishable offense.
And the answer? Well, it usually comes down to this crucial two-word Latin phrase that is all about criminal intent. Honestly, it's one of the most fundamental concepts you'll find in the Indian Penal Code.
Mens rea, literally the guilty mind. You see, this is the magic ingredient that turns a bad act into a crime. The idea is that for you to be criminally responsible, it's not enough to just look at the wrongful act. You have to look at the mental state behind it, the intention to do wrong.
Okay, so how does this actually work in practice? Well, the courts have done this really interesting balancing act. You've got the general rule coming from cases like Queen v. Tolson, which says you absolutely need a guilty mind. But then you have the exception, which the Supreme Court laid out so clearly in M.H. George. Sometimes a law can be written to say that the intent doesn't matter. We call these strict liability offenses, and you often see them in things like public safety rules, where just doing the act is enough to be guilty.
But here's the key thing to remember, the absolute bottom line. Courts always start with the assumption that mens rea is needed. Think of it as the default setting. As a case called Sheras v. DeRutzen established, a guilty mind is required unless the law explicitly says otherwise.
Okay, so we've figured out what might make something a crime. What happens next? How does the state get involved? Well, this brings us to the Code of Criminal Procedure and the super important rules around making an arrest.
This quote from the Supreme Court in Joginder Kumar is huge. It basically says, hold on a second. Just because someone files an FIR, an accusation, doesn't mean you can just go and arrest the accused. The court made it super clear that an FIR is just the beginning of an investigation. It is absolutely not an automatic green light for an arrest. This is a massive check on police power.
And to make sure that power isn't abused, the Supreme Court, in the game-changing DK Basu case, laid down some non-negotiable rules. Now, these aren't just suggestions, they're mandatory procedures. Simple things, right? Like police officers having to wear clear ID, drawing up a formal memo of arrest, and, critically, letting the arrested person tell a friend or family member what's happened. It's all about bringing transparency and accountability to the process.
And the court didn't stop there. The Arnish Kumar judgment went even further, especially looking at cases under Section 498A of the IPC, which is about cruelty in marriage. The court saw how this law could be misused, so they put the brakes on automatic arrests. They said that for any crime where the punishment is less than 7 years, the police can't just make an arrest. They first have to justify in writing why it's necessary. This is a huge step in preventing arrests from being used just to harass people.
All right, we've covered the crime and the process. Now let's switch gears to the proof. And we're going to look at one of the most dramatic and powerful pieces of evidence you'll ever come across in an Indian courtroom.
Wow, no person will die with a lie on his lips. This is the beautiful, powerful idea behind what's called a dying declaration. The law basically believes that when someone knows they're about to die, they're not going to waste their last breath on a lie. That sense of facing death is seen as being just as powerful as taking an oath in court. It gives their final words an incredible amount of legal weight.
And because of that belief, these final words carry incredible weight in court. I mean, think about it. The Kaushal Rao case said a truthful and voluntary dying declaration can be the only thing needed to convict someone. No other proof required. And it doesn't even have to be spoken words. Cases like Laxman and Abdullah have shown it can be written down or even just communicated through gestures as long as the meaning is clear.
But of course, there have to be checks and balances, right? This isn't a blank check. As the court pointed out in Sanjay v. State of Maharashtra, consistency is everything. If a person gives more than one declaration and the story changes in important ways between them, well, that's a huge red flag. It makes it really unsafe for a court to rely on those words for a conviction.
So we've gone through a lot. Mens rea, arrest rules, dying declarations. But why do these specific cases matter so much? What's the big picture here, especially for you and your exams?
It's because they map out the entire journey of our criminal justice system. You've got these three pillars. First, with the IPC, you define the crime itself using ideas like mens rea. Then you have the process with the CrPC, which sets the rules for the state's power, like the safeguards for arrest. And finally, you get to the proof, with the Evidence Act, which gives us tools like the Dying Declaration to find the truth. These cases are landmarks because they are the bedrock for each of those pillars.
So, getting a grip on these principles is about way more than just passing an exam. It's about understanding the why behind the law, the very DNA of our criminal justice system. And here's something to think about. As our world changes with new technologies and new kinds of crime, how are these core ideas going to hold up? Applying this wisdom to the future? Well, that's the real challenge.